Good afternoon. I am Robert Sarton with Frost Brown Todd. We as a law firm, as we move into a season of celebrating our 100-plus year legacy, are happy to be participants of the Southern Automotive Conference, recognizing how important this conference is to the industry and particularly the region that it stands for. As a law firm, we've been actively engaged for decades in the industry globally with our practice areas. Being an attendee and sponsor here, each of us, I think, understands how important the industry is to not only the global economy, but our regional and local economies. And then it ties directly into the purpose of this conference and why we gather together. And I'm happy to introduce our 2 o'clock speakers around the HR revolution. Of course, human resource issues are critical to the performances of our countries. I think we know in the industry there's always some form of tailwind, and you worry about when it runs out and when the headwinds take over. Notwithstanding some uncertainty around certain aspects of the industry, it's easy to see the industry is vibrant in our region. In Tennessee, Mitsubishi recently announced the relocation of its headquarters to Franklin, Tennessee. GM's making a $300 million investment in one of its plants here. Nippon Paint recently announced a new facility in Chattanooga. In Alabama, Mazda Toyota Manufacturing has begun hiring around its $1.6 billion Huntsville assembly plant. Mercedes-Benz is building a $268 million electric vehicle battery plant. In Georgia, SK Innovations is planning to hire 2,000 employees by 2025. Hitachi Automotive has announced a $100 million expansion. Georgia Tech has announced a partnership with Delta Airlines and Curiosity Lab to fund a research environment testing automated vehicles and smart city solutions. In Mississippi, there have been recent investments from Calsonic, S&A Industries, and German-based Hago Automotive. And in South Carolina, Druxmailer introduced a $42.7 million expansion, and R&E Automated Systems just announced a $12 million expansion. A lot of money being invested in the industry in our part of the country. With that, happy to introduce Brice Smallwood and Louise Brock. Brice Smallwood's practice is focused on representing automotive manufacturers, other manufacturers, and employers of all sorts in litigation in federal and state courts, as well as administrative hearings. Mr. Smallwood has experience working on matters involving the NLRA, Title VII of the Civil Rights Act, the Americans with Disabilities Act, Fair Labor Standards Act, the Family Medical Leave Act, and other federal state employment laws. Louise is a colleague of mine. Met her several years ago when she moved to Nashville. Since joining Bridgestone, Louise has served as General Counsel, Labor and Employment in the company's law department here. She manages a team of 6 attorneys and 1 paralegal who provide legal support in all areas of employment law, traditional labor, benefits, and L&E litigation. Prior to working with Bridgestone, Louise spent 5 years at Procter & Gamble as senior counsel in the company's labor and employment law group, and she previously served as an adjunct professor at Northern Kentucky Chase University College of Law, teaching a course in employment discrimination. Welcome both of them for your 2 o'clock panel. Thank you.
Hello, it's like really bright lights here, which is kind of maybe what you see if you're busy doing the stuff that we're talking about today. Lots of bright lights. HR disruption was our topic on the agenda, and I thought about, well, I think marijuana in the workplace fits HR disruption. So that's the topic Brice and I are going to talk about today. We're going to discuss the legal developments of marijuana, the legalization, talk about a little bit on CBD as well and hemp, but also give you some just updates on where the law is going and provide some practical tips, hopefully, on how to work through this back in your office and how to manage through those challenging employee situations.
So despite the rapid change in employment law as far as these medical marijuana and recreational marijuana laws have come in the past few years, it's still illegal under federal law. It's listed as a Schedule I drug by the DEA, and I believe that's been around since the Nixon administration. So for quite some time, it's been a Schedule I along with heroin, LSD, ecstasy. And despite it being illegal under federal law, there's 33 states and the District of Columbia that currently have some form of medical marijuana legalization. And there's 11 states that have gone a step further and legalized recreational marijuana, the most recent being Illinois, and its law is set to go into effect on January 1st of 2020. So it really is a growing trend. I get legal updates every single day where a state has passed new legislation, either medical or recreational marijuana, or there's a new case interpreting some sort of statute or regulation. And it really is, it's a growing field of employment law, and something that employers really need to get their heads around at this point and come up with a plan and make sure that they're in compliance with the different states where they operate in. So the legalization of marijuana, it's been at the center of attention for quite some time. California was the first state to legalize medical marijuana back in 1996. So over 20 years now, this has kind of been at the forefront. And on one side, you have the argument that it shouldn't be legalized in any form or fashion because it's a gateway drug. It's going to lead to certain consequences or ramifications down the road that we don't anticipate at this time. But on the other side, you've got people who are saying it should be legalized. One, to kickstart economic growth in some states. A prime example is Kentucky, who has had the pension issue over the last 18 months or so. But at the same time, Kentucky has a climate that is perfect for growing marijuana. So you have legislators, politicians, and just the public in general. Some people are saying, hey, this would be a great way to kickstart the economy. But the main argument for people who want marijuana legalized is that it's got this medicinal purpose to it. It can help provide benefits to individuals with sicknesses and illnesses. And studies have shown that medical marijuana can help patients with the following: pain control, PTSD, glaucoma, HIV, MS, Crohn's disease, certain forms of cancer, and epilepsy. But really, whatever side of the aisle you fall on with this issue, the legalization of marijuana is here, and it's not going anywhere anytime soon. But while, the states are rapidly passing these laws, there's some unintended consequences. Many of the statutes and regulations, they have no definitions, or they're confusing or ambiguous, and it's really left employers hanging out to dry.
So I thought I'd kick off here a little bit and just highlight some of the real challenging issues for employers. There we go. Brice and I are going to touch on each of these in a little bit more detail, but just to kind of hit them like a highlight to start here. First, it's just the sheer speed of keeping up with all of the laws that are popping up in different states, some legalizing just medical marijuana, others legalizing medical and recreational. And, I'm at Bridgestone here in Nashville, and half of our population is a retail footprint. 25,000 teammates working in Firestone Complete Auto Care stores. We have stores in every state in the country except Alaska. So we have got to stay on top of the developments in each state. And it's a real challenge. A lot of the states don't have case law yet interpreting these statutes. In some cases, there's a conflict even within the statutes, and we've got to be aware of the differences and decide, can we implement a uniform policy? Do we have to have different policies in different locations? So we're really challenged to figure this out. In particular, drug testing comes into play, whether it's pre-employment or testing in a reasonable suspicion situation, or you may have some of your employees subject to DOT regulations, which is a whole other area of compliance. And so we're trying to figure out, can we keep testing for medical for marijuana? What if individual has a medical marijuana card. Now, what do we do with that if they test positive? So it's really trying to work through all of these issues, trying to stay on top of them, and Brice and I will go through each of these in a little bit more detail over the next little while. All right, here's kind of a nice visual to give you a flavor for where the pockets are in the country of these developments. So of the 33 states that have legalized medical marijuana, I believe 18 of them have just come into place since 2010. And of the 11 states that have legalized recreational marijuana, all 11 of those laws have passed just since 2012. So it's pretty recent development and a rapid development. You can see here in Tennessee, there is no law decriminalizing marijuana, so we're still able to say federal law makes it illegal, so we're testing for it, and if you test positive, you fail your pre-employment test. The only state in the southeast here of Florida has passed some of these laws, but you can see it does have a tendency, these laws in the employment world, they start on the coasts and they start working their way in, and that's what we're really preparing for. All right.
So the majority of the states that have enacted a medical marijuana law have some provision within it that prevents adverse employment action based solely on the employee having a medical marijuana card or being authorized by a doctor or physician to use medical marijuana. So essentially these states are saying an employer cannot refuse to hire or terminate, suspend, demote, do anything that adversely affects your employment solely based on you being qualified to use medical marijuana. And the reasoning behind this is because they want to encourage those individuals who could benefit from medical marijuana to go out and do that, to go meet with their physician to see if this would help their condition to get better. Because if not, individuals, they're not going to do it if their employer can just fire them at will based solely on their medical marijuana card. Because at this point, you're weighing the benefits here. Do I get some help for the pain I'm having and risk my job and my livelihood for me and my family? So these adverse employment action provisions are very common. And here's one from Arkansas that I think really does a good job of explaining that, and it's also very similar to most states that have it. So it says an employer shall not discriminate against an applicant or employee in hiring, termination, or any term or condition of employment, or otherwise penalize an applicant or employee based upon the applicant or employee's past or present status as a qualifying patient or designated caregiver. So like I said, that's very, very typical of all the states that have this sort of provision. And again, I do want to emphasize, it's not just terminating. That's what most people think of when somebody fails a drug test, is termination. But it's any adverse employment action. So anything that affects those terms and conditions of employment, suspending, docking pay, putting into a worse position, are also included. But the main issue for employers with these new laws, whether it be medicinal or recreational marijuana, is seen in employer drug testing policies. So certain states have enacted legislation that makes it a lot more difficult for employers to drug test. In some states, it's nearly impossible to drug test in certain situations now, if not completely prohibited. So previously, employers pretty much had the same uniform policies. You could walk into any employer and you knew exactly what was going to happen as far as drug testing. There was going to be a pre-employment drug test. Once you were hired, there was going to be reasonable suspicion drug testing, random drug testing, post-accident drug testing. And if you failed any of those drug tests, you were fired right there on the spot, or you weren't even hired, if in the case of an applicant, because all employers had these zero tolerance policies. So one failure, one strike and you're out. But now the new laws in these states are really reining back on an employer's ability to do that. Some states outlaw zero tolerance policies. And I've got here, as of January 1st, 2020, Nevada will prohibit pre-employment drug testing for marijuana. So this is a huge change. A lot of employers have had the same drug testing policies in place for decades, if not from the very start of the company. And now you've got states like Nevada who are coming in and say you can't even do a pre-employment drug screen for marijuana now. And it really shows the growing trend in the U.S. And growing acceptance from state legislators for marijuana. Now, while some states have employee-friendly provisions like Nevada that we just talked about, other states allow employers to keep the same drug testing policies that they've had in place for years. A great example is Ohio. So Ohio, in the last couple years, has legalized medical marijuana. But importantly, the Ohio legislators created an explicit carve-out to protect the interests of employers. So, for example, the Ohio law does not require an employer to permit or accommodate an employee's use of medical marijuana. The law does not prohibit an employer from taking adverse employment action against an employee because of the use of medical marijuana. And the law, most importantly, does not prohibit an employer from establishing and enforcing a zero-tolerance policy. So like I said, Ohio employers, no big deal. You can keep the same policies that you've had in place forever because there are these explicit carve-outs. But while Ohio employers rejoice because they're not impacted like a bunch of other states, it makes these multi-state employers, it's a nightmare because they don't know what to do. There's different states. I mean, you've got Ohio that allows you to keep your same drug testing policies in place, your zero-tolerance policies that you've had in place for 20 years. But at the same time, if you operate in Nevada as well, now you can't pre-employment drug test. So it's become a headache for HR and the legal team for a lot of employers who operate across the country. So I think at this point it's critical to really sit down and keep up to speed with these new laws, regulations that the states are passing all the time. So that you know if the policies that you currently have are in compliance, or if you need to sit down and tweak them, or completely scrap them in some instances and start over. So this case out of Arizona, I think, is a great example of an employer who didn't take the time to sit down and get up to speed on the new laws that were passed and really paid the price for it. So here there was an employee who was injured at work. She hurt her wrist in a workplace accident, and she was taking medical marijuana to help cope with the injury. Her doctor had prescribed this to her. She was a card holder, and this was a good employee. She was upfront with the employer, went to her supervisor and said, hey, if I do get drug tested, I'm going to fail because I'm taking medical marijuana. Look, I've got this card. It's prescribed to me. I'm not doing anything wrong. Sure enough, she gets drawn for the random drug test. Sure enough, she fails the drug test. And her employer terminated her on the spot because it had this zero-tolerance policy. Now, under Arizona's law, employers cannot take action against a qualified patient for a positive drug test for marijuana unless the patient was either used, possessed, or was impaired by marijuana on the employer's premises. So here what the employer said in court was, look, Judge, she was impaired. I've got this drug test right here. She failed. It's as clear as day. And the court, said, pump the brakes. This isn't how it is. For it to be impairment, for you to show impairment, it's got to be more than just a failed drug test. There has to be something else. You can't rely solely on a failed drug test to show impairment. So employers in Arizona now, they have to focus on impairment. But the issue is, and it's not just in Arizona, there's other states who use terms such as under the influence. What does that mean? Nobody has a good understanding of what that means, and even worse is these statutes and regulations oftentimes don't define impairment. So that's the hard part for employers is, how can I tell if this employee is impaired so that I can drug test, and that'll bolster my argument that I can terminate this employee. But again, this is a good example of an employer who wasn't ahead of the game, or at least on pace with the game, and knowing what they can and can't do as far as drug testing. Now, there's also, to add to the confusion and the mess for these multi-state employers, is a string of cases out of the Northeast where employers really thought that they were in the right. You know, they took the time, they read the statutes, they looked at the medical marijuana laws and recreational marijuana laws and thought they were doing everything correctly just to get smacked down by a judge. And in all these cases, it's pretty much the same fact pattern. You've got an applicant or an employee. They've got their medical marijuana card from their doctor. They're upfront and honest with their employer. You know, an applicant says, I can't take this pre-employment drug test or I'm going to fail. Or an employee comes to their supervisor and warns them that they are currently using medical marijuana. So it's not even like they're trying to hide anything. But somehow they have to take a drug test. They fail, and they're either not hired or they're terminated. And that's exactly what happened in this case out of Connecticut. You had an applicant. She was a medical marijuana user. She failed the drug test, and her job offer that she had just received was rescinded the following day. Now, that prospective employee filed a lawsuit alleging discrimination and violation of the medical marijuana statute. The employer argued that it did not discriminate because of an exception in the Connecticut law, which permits discrimination required by federal law or required to obtain federal funding. So this employer here, they knew that marijuana, whether recreational or medical, is still illegal under federal law. So just based on that provision that allowed them to discriminate, if they were complying with federal law, they were like, this is our ticket out. This is exactly what we did here. We were not going to let this employee use medical marijuana because marijuana is illegal under federal law. But here the judge said that, well, there's no federal law that requires you to maintain this zero tolerance drug testing policy. That doesn't exist. I know that marijuana is illegal under federal law, but it doesn't say you have to have a zero tolerance policy. So this case was really the first time that an employer had been smacked down for using this argument that marijuana is illegal under federal law. That defense had worked for years and years and years. And this was the first time that a judge finally said that that's not good anymore. So the next case, again, we've got an applicant who was given a job offer that was contingent upon her passing a drug test. Again, she, medical marijuana user, very upfront, told her prospective employer, hey, I'm not going to pass this. And she, of course, didn't. They rescinded the job offer. And she filed suit under the Massachusetts medical marijuana law. And it's a very interesting case because the judge kind of went above and beyond what the issue was. You know, the issue is this a violation of the medical marijuana law? Well, the judge, turned the pages a few more in the legal book and said, oh, it doesn't fit under medical marijuana, but we do have this disability law here, our state disability law. And the applicant suffered from Crohn's disease. And the judge said, since Crohn's disease is a disability under Massachusetts disability law, the employer had a duty to engage in the interactive process with the applicant to determine if there was a reasonable accommodation that could be made. So this, like I said, this is a very interesting case because the judge said, all right, you might not fit within the medical marijuana provision here, but we'll open the books up to allow you to bring a disability discrimination lawsuit. And it's important because if you think about it, who are the people who are getting medical marijuana cards for their doctors? The list I showed earlier, people with HIV, glaucoma, PTSD, all things that are likely going to qualify as a disability under any state's disability law. So this case is really important because it gives plaintiffs and employees and plaintiffs' attorneys kind of a roadmap as to how to attack a termination or any adverse employment action just based on them testing positive for marijuana in their system. And again, it's important too because this is a string of cases, like I said, out of the Northeast who are kind of writing into these provisions their own thoughts and opinions. So it's good to keep a pulse on what's going on, because you see this trend in the Northeast, and you as an employer, if you operate in the Northeast, it's something to keep in mind when crafting your policies. And in the final case here, again, it was an applicant. She failed a pre-employment drug test and sued. And the first issue, was whether there was a private cause of action for her to sue under the medical marijuana statute. On its face, it was neutral. It didn't say anything about allowing an employee or applicant to sue if they had been terminated or refused to hire because they failed a drug test. But the court here said, look, our legislature has passed this medical marijuana law. Clearly, they intended to protect applicants and employees, so it's fine. There's got to be some cause of action here for you. So that was issue one. Even though it didn't look like on its face that they were, they could file suit, the judge allowed it. The second issue, again, was the disability. Brought a disability claim. And with respect to this claim, the court held that discrimination could be shown against a class of disabled people, namely those with disabilities best treated by medical marijuana. So again, now you've got two states, at least, who have said, okay, it might not fit within the medical marijuana statute, but this person's disabled. You're going to have to engage in that interactive process and see if there's a way that this person can be reasonably accommodated.
All right. So this guy knows his stuff about all those cases. You might not believe this, but I don't have time to read all the cases, right? We're dealing with the day-to-day. We're getting the frantic calls from HR, trying to work through these issues. Things pop up we haven't seen before. And so I'm calling this guy to say, what's the latest on some of the legal developments? Anybody ever put a call into your lawyer and you ask them a question, they say, it depends? Well, that's starting to happen too with this area. Some of the laws that are legalizing marijuana, either medical or recreational, are silent on the impact on employers. Can employers still drug test? How do we deal with a positive drug test? A lot of the laws aren't as clear as Ohio's, which nicely lays out it's legalized, but employers, you can still maintain your policies. There isn't that extra protection for the employees. So when the law's silent, we're in dangerous territory and we're exposed to potential litigation by continuing to take a hard line on marijuana drug testing. Another complicated area here for us, an ambiguous area, are states that have these lawful use laws. The idea here is that your employee is engaging in lawful behavior outside of work. Kind of think about that off-duty conduct kind of concept, and employers aren't allowed to take adverse action simply because their employee was doing something lawful outside of work. Well, when the laws pop up that say, well, marijuana is now lawful, so now that is lawful behavior, and so employers, you can't take action, you can't refuse to hire or terminate your employee just because you heard he was at a party smoking pot. Or they come to work and you hear stories. So now you've got this dilemma, this ambiguity about being concerned about a potential impairment at work, but you've got to face these lawful use laws. Illinois has got a new statute coming into play that is one of these laws that on its face it just contradicts itself. It has a lawful use law that protects marijuana use, but then it says, so employers, you can't take action just based on lawful use outside of work. But hey, you can still have zero tolerance drug testing policies. I'm like, what? So can I drug test and then take action if it's a positive? But no, wait, it's lawful use. So there is an inherent conflict that the legislature has not sorted out yet in Illinois. And so we've got a dilemma as an employer to decide what position do we want to take. There isn't enough case law yet to interpret these inconsistencies. And so you've got to step back as a company and you've got to assess, what do you want to do? Let's flip to the next. Great. So one safe space to be in is the concept of impairment. We can still have policies that say you can't use drugs and alcohol at work. You can't deal at work. You can't be under the influence or impaired at work. Now, Brice hit on a little bit of the dilemma that what does it mean to be impaired by marijuana? How much does it take? In the world of alcohol, we know what that is, right? Medicine, science has figured that out. They haven't figured that out yet with marijuana. There's inconsistency in the product. How often are you smoking? When was the last time? And what can you handle? And so we're not exactly sure what impairment is. We've got some guidance from a law like in Illinois where they actually say, hey, these are behaviors that give you a foundation to say you have an impaired employee. A lot of that doesn't exist. Some companies are even bringing in experts outside to train their supervisors on how to spot impaired teammates, what to look for. So that's a challenge. A positive drug test is probably not going to be enough. If you've got a positive drug test and some other behavior, you're on pretty solid ground to say, we have an impaired teammate under our policy, we're going to enforce our policy, and you'll be in pretty solid ground in most places. We mentioned Missouri here, just being so close to Illinois, you could very well have operations in those two places, or teammates that live in one and work in the other. We don't really know what impairment means in Missouri. So again, just highlighting for you guys the things to really think about. As an employer, I think it's important to think about your own risk tolerance and decide, do we really have safety-sensitive positions? Do we want to err on the side of bringing the hammer down and take some risk that we might get it wrong, but we need to emphasize safety? So that's something to think about. Thanks. So that's something we flagged here as one of the bullet points on this slide as a tip. Even in these places where disability discrimination is coming into play, where Brice talked about the cases coming out of the Northeast, if the courts are going to view the marijuana use as evidence of a disability, or they'll have an underlying disability, which is why they're taking the marijuana, you are on solid ground to then think about it from the disability accommodation standpoint. We don't have the obligation to allow employees to be unsafe at work. And if taking any kind of medication, any prescription drug, could create a threat to safety, then that's something we can say, nope, we don't have to accommodate that. And so if you think about your safety-sensitive roles, and you can take a harder line with those positions. Focusing on impairment we've mentioned, and you got to know the laws in your state. Can you be stricter in certain places? Do you need to back off and reevaluate your strategy depending on where you have your workforce? Whatever you decide to do, it's really important that you capture it in a policy. Because one thing that's going to always work well for you is if you can argue that your employees knew the rules, they knew the consequences of breaking those rules. And so people who know what to expect, that's going to also help. You won't have an employee who's surprised. If you've got someone who tests positive and, oh, miracle, they have a medical marijuana card, you'll say, well, you knew our policies. You needed to let us know about that so we could have had a discussion about whether we could accommodate that. And you didn't do that. So you're on a better stand to come down harder on that employee in that situation. If you have that policy, be sure you follow it. Be sure you're consistent in how you apply it. And make sure those managers who are out there dealing with it on a day-to-day basis understand what it is and are trained in how to follow it. A reminder here, last point on this slide, is that if you do have a workforce regulated by the Department of Transportation, those federal rules still come into play, and you can have a much stricter drug policy with your DOT workforce.
So you mentioned accommodations. Do you have any examples of times that you've had to accommodate an employee or looked into it?
Yeah, thanks, Brice. We actually had a couple cases in the Northeast, both in the pre-employment process. So the first guy applied for a job as one of our vehicle service technicians, which we consider a safety-sensitive job. Went through the pre-employment, popped a positive on his drug test. It was marijuana. He produced a medical marijuana card. And we said, all right, we're in a state where we have to step back, analyze the disability component of this. And so we had HR engage in the interactive process. Talk to this teammate about the situation. Now, first of all, didn't know our policy when he went in for pre-employment drug testing. And that's pretty different from a current teammate who knows the policy. So we have a conversation with him. We explain that this is a safety-sensitive position. We can't have anyone under the influence at work. We don't tolerate marijuana use for this job. This guy wrote us a note committing to not taking it anymore. He'll work with his doctor on other alternatives. He understands our policy. He will comply. After talking to him, HR thought the guy is being honest. He's genuine. He's committed. And so we took that at face value, and we went ahead and brought him on board. We had a second case, similar kind of conversation, and what we ended up doing is we actually had a position that was more customer service oriented in the front of our store that we don't consider safety sensitive. And so that position was open, and we then presented a job offer to the individual for that job, where we could accommodate his medical use. So just really, in the time it takes to go through these, we hire about 1,000 teammates a month in our retail stores. There's only, how much time you got to have these one-on-one conversations, but that's what you really need to do in these key pockets in the country.
So now on to the rise of CBD oil. I mean, this is obviously one of the biggest trends in the country. It's sold everywhere, grocery stores. I mean, you can get it at Kroger, Walgreens, CVS. But at the same time, the scary thing to me is that you can get it at the gas station or literally any store you go into. The golf course I belong to sells a single pill for $60, and they cannot keep it on the shelf. Now, to be completely honest, I mean, if you're selling anything at a golf course that allegedly is 5 strokes off your game, it's going to sell like wildfire. But that really does show. I mean, it's at golf courses. So it's a huge topic right now. So I'll give everybody 15 to 20 seconds to read this slide. All right, everybody got it? Fully understand? Because now you know just as much about CBD and hemp as I do. And that, that's really a scary thing. We don't know what's in the products. Nobody knows what hemp, CBD, I mean, I can't even pronounce half the words on the slide, much less know what it actually means. And that's a huge issue for employers because they've got these employees who are saying, well, I took CBD oil, but they don't even know what's in it. Now, while hemp and hemp products are no longer illegal under federal law, food, dietary supplements and cosmetic products made from or including a hemp or a hemp byproduct remain subject to the FDA authority. And because CBD is an active ingredient in FDA-approved drugs, the FDA has taken the position that its addition to foods, including animal foods, and dietary supplements is illegal. Now, as far as cosmetic ingredients, the regulations are a little bit different, and the use of CBD in topicals is generally legal as long as the manufacturer can establish that the product containing the CBD is safe when used as intended. So as far as the states go, hemp production, at least pilot program legislation, has been adopted now in 47 states, including Tennessee, although implementing regulations are still in the beginning phases for many of these states. There's only 3 states, Idaho, Mississippi, and South Dakota, that do not have legislation authorizing hemp production. So of these 47 states with authorizing production, 27 explicitly permit retail sale of hemp-derived CBD products. 11 neither explicitly permit or prohibit CBD products, and the remaining states have statutory provisions raising concerns about the legality of the sales or have a provision that explicitly prohibits the sale.
So we've got to deal with this too. So let me start with a story that we had. We've got an HR contact center that can take calls from our employees. And when they don't know the answer to the question, they call legal. So I get a call from them. We've got an employee that sent a note saying that he wants to know, can he use CBD oil for his medical condition? What's our policy, and is it okay if he uses it? Well, we haven't written a policy on that. We haven't outlined guidance for that. Our HR contact center didn't know how to answer that question. So now I'm staring at my computer screen. This is all email, which is all we do, I think, half the day, right? I'm looking at my screen, I'm thinking about this. I'm like, all right, well, this is where things are going. This is now legal. What is our position on this? I just sat through a vendor presentation from our pre-employment vendor who's telling us about some of these legal developments in CBD. And I'm hearing from our vendor that CBD oil should not have enough THC in it to trigger a positive drug test. So I think, well, we want to tell this employee that we have a drug-free workplace policy. You can't be under the influence at work. If you test positive for marijuana, given where this employee works, it would be a violation of the policy. You may use CBD oil, but it will not be a basis for to explain a positive drug test. So keep that in mind, employee. So that's not super clear. Does the employee know what he's getting? And that's the big part of the dilemma here with CBD oil. It's not regulated. Like Brice said, you can buy it all over the place. Our employees don't know what they're getting. And if something happens at work, they're in an accident, there's some incident that triggers a drug test, they test positive, they might say, well, I've been using CBD oil. That must be why I had a positive drug test. Our position is that should not be the reason for a positive drug test. And you're in a safety-sensitive job. You can't be using marijuana. Well, I don't. It's just CBD oil. You tested positive. CBD oil should not be the explanation for it. In this individual's case, maybe it was. but we're going to act now on a positive drug test under our policy. So that's a real dicey area for our employees in making decisions as well on how to treat themselves. And the other piece with being unregulated is how much should the person take? How much is too much? How much could tip the scales on a positive drug test? So another area with a lot of nuance to try to figure out how are we going to operate all across the country when these issues pop up. All right.
Yeah, so one last thing here. What I think is very important for multi-state employers is knowing what to do with states with conflicting laws, or if you operate, in all 50 states, what are you supposed to do with your policy? So could you talk about what you do at Bridgestone as far as your policy? Because you do operate in many states and there are conflicting laws. How do you go about drafting that policy?
Yeah, so we do have a corporate drug-free workplace policy. And it's going to have that catchphrase in it in a bunch of places, subject to state and local laws, or except if prohibited under state and local laws. So we want to have something as uniform as possible, but then we are in the process of developing state supplements. We've had some that have been in place for a while that have slowly become outdated, and we're brushing those off and creating guidance. A lot of it's guidance for HR, who's going to be dealing with the hiring process or reasonable suspicion drug testing, and we'll develop that guidance. And I'll tell you where we are overall leaning, even with all the ambiguity and the conflicts, is in states that have legalized medical marijuana and that have provided some protection to employees, whether in the statute or through case law. We're going to treat it like we treat a disability and go through that analysis. We're going to say, what are the essential functions of this job that either the person's applied for or that they're currently working in? Is it safety sensitive? And if it's a safety sensitive job, we will not accommodate marijuana use, even medical. But we're going to engage in the interactive process, certainly in the hiring process, where the individual doesn't know our policy yet, they haven't worked for us yet, like the two examples I shared before. Just figure out, can we accommodate this individual? Will they stop using? Or do we have another position available? So we'll engage in that discussion. And it's a time-intensive effort for our HR staff to be having those conversations. But in the parts of the country where it's clear in the law that we don't have to accommodate in some way, there isn't an employment protection, we're going to stay strict with our drug testing policy.
Great. Well, I want to thank you all for your time. I hope you found something helpful from this. I know I'll stick around for a little bit if there are any questions. But the last thing I want to say again and reemphasize, read the laws, know what the laws are in the state where you're operating, and make sure that your policies and what you actually practice are in complete compliance with it, and you won't have any issues. So thank you all again.
Thank you.